discuss this ruling and more is Neama Rahmani. He is a former federal prosecutor and the president of West Coast Trial Lawyers. Neama, always great to see you. So, Trump and his team, of course, are appealing, but interest will also mount on that enormous fine and penalty of $354 million. So, while on appeal, does Trump still have to put down a down payment or collateral of some sort or a bond covering the full amount?
Yes, Fred, nothing comes for free. And we know for the first Jean Carroll defamation verdict, Trump did put $5.5 million in escrow with the court. But now we're talking about approximately $500 million. Even for someone like Donald Trump, I don't think he has that type of money laying around. So he's likely going to have to get an appeal bond and put up a percentage cash, and the rest will be secured by collateral. And then once he puts that appeal bond up, then he'll be able to appeal.
So even though, according to the Washington Post, Bloomberg Billionaires Index recently estimated Trump's net worth of $3.1 billion with $600 million in cash assets. So before potentially selling off any property, could the court make him kind of cough up from the cash assets?
Well, while the appeal is pending, one of two things will happen. The Court of Appeal will decide to stay or pause the judgment, the order from the trial court below. We know that Trump loves those stays. That's what's happening in the D.C. election fraud case. But if the judgment is not stayed, then whether it's Jean Carroll or the New York State Attorney General, they can start enforcing those judgments. They can go after Trump's assets, his bank accounts. They can levy any wages, or they can attach and put liens on his property, potentially even foreclosing on them.
So as part of the penalty, the court ordered an independent monitor of Trump's businesses as well. So how does that work, and when would that kick in?
Well, Fred, this was one of the only wins for Donald Trump. Of course, before the trial, Judge Engoron canceled Trump's business licenses and his entities would have been dissolved. Now that ruling was put on pause or stayed again by the Court of Appeal. So now what the judge said is we're going to continue to monitor the retired federal judge. And in addition, the Trump entities have to hire an independent compliance officer. So before they submit financial statements to anyone, these two individuals need to review them to make sure they're accurate.
Okay. All right. So now on to the Georgia Fulton County District Attorney, Fani Willis, who defended herself in quite dramatic, powerful fashion against allegations that she financially benefited from her romantic relationship with one of the prosecutors. Is this an easy decision for the judge based on what you and everyone watched?
Well, I think it's an easy decision not to dismiss the case. Willis's and Wade's alleged misconduct is not going to result in dismissal of the case against Trump or any of the co-defendants because there's no conflict of interest. They're on the same side, but there's certainly an appearance of impropriety and there's likely ethics violations based on Willis's own testimony. I think she should step down and Wade should as well, and career prosecutors in Fulton County should take over the case because there is a real possibility now, because she's doubled down on all this, that the whole DA's office is disqualified.
Right, and that's pretty sizable. But then from the point of view of the allegations the co-defendants made, do you feel like they proved their allegations against Willis?
I don't think they necessarily proved that Willis financially benefited, but now there's this whole cloud that's hanging over the case. And even if it moves forward, there's a potential appellate issue. So the question is, even if there's an appearance of impropriety, you are a public service, Fani Willis. You're a public servant. So why are you using public funds to pay your boyfriend $500,000 or $600,000? Even if everything's on the up and up, this is not something that has the appearance of being appropriate. So I think they should step aside. I think legally, though, if Judge McAfee rules that there is no conflict of interest, that Willis didn't pay her boyfriend and receive any benefits, she'll be able to stay on the case. But again, we're really kicking the can down the road, and this case has already been delayed for so long because it was the last one to be filed. There's 19 co-defendants, and now you're creating unnecessary issues on appeal.
How much longer do you think Judge McAfee will need in order to render a decision?
I think he's going to render a decision next week. He's moved pretty quickly when it comes to his orders. And we need to keep this case moving. Obviously, it was the last to be filed, and a lot of this is Willis's own doing. And she charged 19 co-defendants. Some of them have pled, of course, like Sidney Powell and Ken Chesbrough. But this case is going to move at a snail's pace. We even saw when she was testifying, we have a dozen defense attorneys that are conducting cross-examinations, and we've seen other cases like this, like the Young Thug trial. It's going to move slowly, very slowly, Fred.
Yeah, the co-defendants did have a big legal team. All right, Neama Rahmani, thank you so much. Great to see you.